The bank alert hit my phone at 11:52 p.m. I was sitting at the kitchen table with my laptop open, reviewing documents for my divorce hearing the following week, when the notification appeared across the screen. $75,000 transfer completed from our joint savings account. The same account my ex-husband had claimed barely existed in his financial disclosure earlier that afternoon. I opened the banking app immediately. The balance had dropped. I refreshed the page. Once. Then again. The number didn't change. I opened the transaction history. That's when the second number appeared. $60,000. Sent the previous week. Same destination. Same external transfer. I scrolled again. $50,000. 2 weeks earlier, there were 6 transfers total, all within the last month, all going to the same unnamed external account. I grabbed my phone and started taking screenshots. Every transaction, every timestamp, every detail. By the time I finished scrolling, the number at the bottom of the page made my hands pause over the keyboard. $302,000. Gone. We'd been married 11 years. A house, a joint investment account, a consulting business we had built together, and what I believed was a shared understanding of how money worked in our family. We'd been in divorce proceedings for 4 months, still living separately, but still sharing accounts for household expenses while the lawyers sorted the details. I thought I knew what we had. The court had issued a temporary order when the divorce started. No major asset transfers, no moving money, no altering shared accounts. I opened the PDF to be sure. The wording was simple. Neither party may transfer or conceal marital assets during proceedings. I read that line 3 times, then I refreshed the banking app again. Nothing changed. For a moment, I tried to convince myself there was another explanation. Maybe he was moving the money to a different shared account. Maybe his attorney had told him to reorganize funds. For 11 years, trust had never felt complicated. I assumed that counted for something. But the numbers on the screen didn't look like a mistake. They looked deliberate. The next morning, I checked the account again before work. Another transfer had gone through overnight. $40,000. Timestamp, 2:14 a.m. Same destination. Same external account. I took another screenshot. Then I opened the Login History tab. Every access record listed the device used to log into the account. Most of them were mine. But the last 4 entries belonged to his laptop. The IP address matched the one he used at home. That part wasn't subtle. I stared at the transaction list for a long time. Then I opened the financial disclosure he had filed with the court. His document listed his retirement account, the business account for our consulting firm, a small brokerage fund, and $42,000 in liquid savings. The joint savings account wasn't listed anywhere, not even mentioned, which made the numbers even stranger, because the account had held more than $340,000 before the transfers started. I opened the banking app again and refreshed the page. Still $27,000 remaining. Still both of our names on the account. Still 6 transfers totaling just over $300,000. The banking app didn't list the receiving account name, but it did show the routing bank, a regional bank located about 20 miles away. I wrote the name down. Then I opened the public business registry site out of habit. Our consulting company filings were there. Annual reports, ownership information, everything unchanged. But another record appeared underneath it. A new LLC, registered 3 months earlier. Same business address, same contact phone number. The owner listed was only him. I stared at the formation date, 2 weeks before the first transfer. I refreshed the page just to make sure I wasn't misreading it. He had opened a new company. Then he started moving money. 6 transfers, all within a month, all leaving the joint account. None of it appearing on his disclosure to the court. My chest didn't tighten from anger. It tightened from understanding exactly what he had assumed. He assumed I wasn't paying attention. He assumed that if he didn't list the account, it simply wouldn't exist. He assumed the money would be invisible by the time any hearing happened. That was the mistake. That afternoon, I emailed my attorney. I attached everything: transfer screenshots, account balances, login history, the LLC registration. 30 minutes later, she called me. Her voice stayed calm the entire time. She asked about the account, asked about the court order. Then she asked one specific question. Is the account still joint? Yes. Your name is still on it? Yes. She paused. Then she said something simple. Keep every record. She filed a motion for full financial disclosure immediately. Transaction histories, receiving account records, financial statements from the LLC tied to the transfers. There were no accusations in the filing, just documentation. I didn't mention the transfers to him. I didn't ask about the company. I just kept checking the account every morning. The balance stayed the same. $27,418. The hearing was scheduled for the following week. When it began, the judge reviewed the financial disclosures first. My ex-husband sat across the room from me, calm, confident. His attorney confirmed the asset list: savings, retirement funds, business revenue. Then my attorney stood up. She handed the court a printed stack of bank records, 30 pages, transaction histories, dates, amounts, every transfer highlighted. The judge spent several minutes reading through them. Then he looked up and asked my ex-husband a single question. Can you explain these transfers? My ex-husband said the money had been moved for business investments, temporary holdings, funds no longer part of the marital account. My attorney slid another document across the table. The LLC formation record, 3 months old, owned solely by him. Then the receiving bank trace. The transfers from the joint account had gone directly into that company's account. The room went quiet because every transfer happened before he filed his disclosure, which meant those assets still had to be reported, and they hadn't been. The judge ordered full financial records from the LLC. He also froze the remaining funds and required the $302,000 to be included in the marital asset pool until the case concluded. My ex-husband didn't say much after that. Over the next month, the paperwork continued. Bank statements, wire confirmations, corporate filings. Everything matched the screenshots I had taken that first night. Every dollar was traceable. The court treated the money exactly as if it had never left the joint account. Half of it remained mine under the division of assets. The LLC he created stayed his, but the money inside it was no longer invisible. The last time I logged into that old savings account was the day the divorce finalized. The balance showed 0. The account had been closed. but the transaction history was still visible. 6 transfers, 6 timestamps, $302,000 moved, exactly the way he recorded them. I sat at the kitchen table that night. The house was quiet. The accounts were separated. The filing was done. He had spent months assuming I wasn't paying attention. He forgot the notifications go to both account holders. He forgot a subpoena doesn't care what you chose not to disclose. He forgot my name was still on the account. I used to think I had discovered the betrayal that night, but looking back, he had already documented everything himself. All I did was open the app. I thought our situation was unusual, until I started hearing how many of these stories begin with a bank alert at 11:52 p.m.